CCTV footage for the purpose of a disciplinary. Before considering whether to use CCTV footage, which may show and or substantiate that misconduct has happened, employers need to be very careful before doing this. So if this is the first time you're seeing me, hi, my name's Amy. I run a page dedicated to employment law in the UK. So if you're an employee or an employer, you're definitely going to want to follow me. But let's get on with this one. So any footage captured via CCTV is classed as personal data under the General Data Protection Regulations. So there are considerations to take into account. First, in order to even capture CCTV, the organisation would be required to register with the ICO and pay the relevant fee. Exception to some circumstances, employees and public, if relevant, should be notified that CCTV is in operation using signs. The employer should also communicate to the employees that CCTV footage captured may be used within disciplinary proceedings. You need to have signs of where the CCTV is in operation. Make sure that it's not within any private areas, which may breach human rights. The sign should state the purpose of what the CCTV is being captured for, so who to contact for any queries of your data. Ideally, you would conduct a data protection impact assessment to identify where the CCTV is and what it might capture. You need to identify, document and communicate your lawful basis for capturing the CCTV. So there are specific ones to choose from under the GDPR. This should be included within your data protection policy and also communicated to staff. The employer needs to consider whether there are any less intrusive methods that may be utilised in order to meet their objective. To notify employees, sometimes this is placed in the employee handbook, but it's important that the employer can provide proof that the employees have 1 received, 2 signed, 3 read and 4 understood it. Sometimes a standalone letter is used as well. If an employer is planning on relying on CCTV footage in order to use as evidence of gross misconduct, it's also a good idea to put it as an example in the disciplinary policy. So risks to the employer if they collect CCTV and use it in disciplinary proceedings unlawfully. Potentially the ICO can fine organisations in the event of a breach. It may be considered a breach of human rights. It constitute a constructive dismissal claim where the employee claims that the implied term of mutual trust and confidence is broken down between themselves and the employer. Or maybe if an employer goes on to dismiss an employee in regard to the CCTV and they've collected it unlawfully, the employee may have a claim for unfair dismissal. It's also worth noting that the ICO have stated in the past that constant surveillance of CCTV is rarely likely to be justified. So for example, a manager that sits in the office watching the CCTV all day, it's unlikely that's going to be justifiable. Additionally, capturing audio recordings are only to be used in the rarest of circumstances, exceptional circumstances, and again, are very rarely justified. I hope that helps. Thanks.